The law is for everyone to follow, and no one is exempted from it, not even lawyers. No matter how intelligent they think they are, karma always gets them. Can attorneys get away with anything? Can they sway a ruling in favor of their clients or even themselves? Watch the video to see how these attorneys get owned by cops for breaking the law.
Las Vegas attorney in some trouble for a series of alleged late-night rendezvous with one of her clients.
Hal Uhrig, an area criminal defense attorney from Orlando, made headlines all over the country. Hal Uhrig, who represented George Zimmerman in the Trayvon Martin shooting incident, was arrested on various charges, which included soliciting perjury and tampering with a witness or victim. Marcos Lopez, Osceola County Sheriff, said that Uhrig took on a case involving a man named Krishnath Prasad, who had been charged of raping a 9-year-old girl. Uhrig was accused of holding a meeting with his client, the victim, and her father. Uhrig tried to cut a deal to keep the suspect from going to jail. During their meeting, Uhrig instructed the victim and her father to do 3 things. Firstly, to write a declination, that is a letter to the state attorney saying that the rape never happened.
Basically a letter to the state attorney saying the rape didn't happen.
Secondly, to avoid being served a subpoena so that they didn't have to go to court to testify, and lastly, to lie during their deposition and say that the rape didn't happen. According to Lopez, he wanted to make sure this guy didn't go to trial for rape. He added that Mr. Prasad committed the sexual battery at a time when she was 9 years old, and this is what caused Mr. Uhrig to work a deal out with the victim to try and get Mr. Prasad off on a lesser charge so that sexual assault battery cases will go to trial, and this will be a separate trial against the attorney. Even after being pressured to such an extent, the victim decided to come forward and report the conduct to the state attorney's office in July of 2021. Osceola County started an investigation against Prasad's attorney on the basis of the victim's complaint. The victim's father engaged in a controlled phone call with Uhrig and said that he couldn't talk on the phone about any specifics and wanted to meet in person. According to the officials, the father wore a recording device during his meeting with Uhrig, and during the meeting, the attorney made him turn off his cell phone and told the father to read a script off of his computer screen.
He wore a recording device, the victim's father. During the meeting, the attorney made him turn off his cell phone.
Lopez said that the script was his defense for when he goes to court on the charges. However, fate had other plans for them. Prasad, who was arrested back in 2019, is working his way through the court system. On the other hand, Uhrig is accused of soliciting to commit perjury, which is a 3rd-degree felony, and also for tampering with and harassing a victim, which amounts to a capital life felony. Given Uhrig's 40-year-long career, this might not be the first time he has done something like this. According to Lopez, if you're an attorney, you've been practicing law for a long time, and there's no way you're going to jeopardize your career on something like this, especially at that age. Especially at that age, it's retirement time. So I think this wasn't his first rodeo. Unless someone else comes forward, we won't know that, but that's what I suspect this time. The next attorney in line is Alexis Plunkett. This topsy-turvy case involves a 38-year-old attorney from Las Vegas named Alexis Plunkett, was indicted with 2 counts of conspiracy to unlawfully possess a portable communication device and 12 counts of a portable telecommunication device by a prison. The charges relate to her visit with her 28-year-old client and boyfriend at the time named Andrew Arevalo. This man was shot in the face by a high state correction officer in 2014. He also faced felony and weapon charges and was awaiting trial. His case was represented by Plunkett in his lawsuit against the Nevada Department of Corrections in connection with the shooting, which resulted in another man's death. During her visit, security camera footage shows Plunkett handing over her phone to Arevalo. Now, this is a felony that could land her in jail for a year. However, her case took a complicated turn. Even though the couple started off as boyfriend and girlfriend, they were experiencing rifts in their relationship after her phone was examined by the police. It seems that she is trying to put a hit on Arevalo. Her text messages about her joking about felonies led her to her downfall. Some of the texts read, "I've placed hits in every Nevada prison on Andrew with every homie and lifer I know." She further added, "This pause will never survive in prison now. He's F with the wrong bit. I am not the one. I represent all the sure-knows and he's gonna get it." However, one of the people in the group asked her to delete the message. He said, "Alexis, this isn't funny. I know you are under a tremendous amount of stress, but I'm not interested in joking about felonies. I don't think anyone is either." She replied,
"I am not joking. That's why I said to delete it. He said he was going to have me murdered, so I'll take care of business first."
Plunkett's attorney Adam Solinger said that her messages show that she was under great stress and she was only venting about the bad situation she was in, and that her words shouldn't be taken as a serious threat. Despite all of her 14-count indictment, Plunkett was dismissed by the district judge Michael Villani. However, she was shockingly arrested again for charges of bribing or intimidating a witness, which is a felony. According to her lawyer, her guilty plea comes after reaching an agreement with prosecutors. The agreement is a good resolution for all sides involved. It's the choice that she made that's best for her, and I respect that. Ultimately, it came down to being tired of continued litigation. Fighting a war on two fronts takes a toll on you, and remaining in custody pending your trial and resolution of your other case is really hard to do. She pleaded guilty of possession of a telecommunication device and was ordered to serve 3 years of probation and was later disbarred. In the next case, Christopher Reynolds, a 44-year-old Florida attorney, shocked everyone. He was accused of stealing nearly $800,000 from his clients. He was arrested by the Pinellas County Sheriff's Office for multiple charges, including money laundering and grand theft. He started his private practice in Seminole back in 2015, representing victims of vehicle crashes. He had dealt with at least 16 clients before they had their money stolen by Reynolds. It was back in October that the detectives came to know about the theft when one of Reynolds' clients came forward. The client complained to the authorities that her lawsuit for $100,000 had been settled months earlier. However, Reynolds never notified her about this. The investigators made a shocking discovery. Reynolds had forged his client's signature on the legal documents and collected the money from insurance companies that should have been disturbed to pay medical bills and provide other compensation related to car accidents. This was a similar pattern for most of the clients that had availed his services. Once he had settled his case, he would disappear without a trace, never to be seen again. He would neither pick up the calls or respond to the voicemails, and would cut off all forms of communication he had with the client's eye. In another incident, the lawyer pocketed the woman's $100,000 and continuously lied to her in the communications before it abruptly stopped that he was going to solve this with the insurance company. He also forged the woman's name on settlement documents, and he never paid her medical bills with the settlement money. His highest theft amounted to $148,750 from a client back in 2019. Sheriff Gualtieri claimed that the clients must have had serious injuries for their settlement money to be in 6 figures. Now, what did he do with the money he stole? The answer will shock you. The lawyer had a drug abuse problem. He used a portion of the stolen money to purchase drugs and nearly spent $30,000 on pornography and $424,000 on prostitution. Sheriff Gualtieri later commented, "They're licensed to practice law. They've got the boxes checked. They've got the credentials. They've got the credibility that goes with that, and they're really just a thief who is ripping them off." These are not isolated cases. Many lawyers who are corrupted and have been cheating people for years are roaming free in this world with no one to put a check on them. What do you think of these lawyers? Were they punished approximately? Let us know your thoughts in the comments below. Don't forget to press the bell icon and subscribe to our channel for future updates.
On September 29, 2019, Deputy James and Deputy Zhang from the Shelby County Sheriff's Office in Tennessee, a potentially dangerous engagement unfolded due to their reckless actions. The incident began when the officers responded to a call regarding a package theft based on doorbell camera footage. The complainant, Mr. Aaron Branch's girlfriend's mother, alleged that a neighbor had taken a package from her porch. Upon arriving at the scene, Deputy James and Deputy Zhang engage with the witnesses, specifically Ms. Vernita Eccles, who identified the neighbor across the street as a suspect. She further mentioned that the neighbor might have a bench warrant for her arrest. Within minutes, the officers made their way across the street to confront the neighbor, seemingly without validating the claims made by the callers. Surprisingly, Deputy James immediately announced his intention to arrest the neighbor without properly investigating the situation. It was during this engagement that Mr. Branch, the original recorder of the incident, arrived on the scene while openly carrying a firearm on his hip. He questioned the officers about the package's ownership, leading to Deputy James ordering him to disarm for officer safety. However, Tennessee law permits citizens to bear arms for self-defense, and there's no requirement to disarm themselves around officers unless there's a legitimate safety concern.
Yeah. Okay, now that box that came off the front porch, did y'all see a name on that box by any chance?
We didn't get a chance to look at it because it was stolen before we got a chance to.
Now, if we show you guys what the box looked like, how you doing, sir? Are you an officer, sir?
Put your hands up, man.
I don't need to put my hands up.
This is for officer safety.
I don't need to put my hands up.
Put your hands up, dude.
The situation escalated as Deputy James unholstered his firearm, which Mr. Branch rightly challenged. This action was unnecessary and potentially dangerous escalation, as Mr. Branch was not displaying any behavior that indicated he posed a threat to the officers. Deputy James cited a state statute to justify his actions, but his interpretation was flawed considering the circumstances. Furthermore, the officers threatened to arrest Mr. Branch and his girlfriend for disorderly conduct, despite being on private property.
The proper procedures, you're supposed to ask if he has his handgun permit.
You don't know. Okay.
Yes, I do.
Hey,
yes, I do. We went to the class. Yes, I do.
I don't need to keep my hands up. I haven't committed a crime.
Yes, put your gun away.
I am not
For officer safety.
You asked to see his permit.
Okay,
can he just step in the house then?
No, I need that car.
We're not talking to you, man.
No,
my car right now.
We're not talking to you right now.
You asked to see.
We're not talking to you
Go
right
in the
now.
house then.
I don't need to go in there. I haven't committed a crime.
You have a permit.
I did have
Why is your gun
Where's your permit?
gone?
Amber, record Officer James. We're gonna make a star out of today. I'm gonna make a star out of
Come
James
on.
today. I'm gonna make you a star, James. I'm gonna make you a star today.
Step away, man. We're not talking to you.
Okay.
Let me see your permit.
Okay.
Keep this arm up. Let me see your
I
permit.
don't need to keep anything on. I can do whatever the
This is officer safety. No, sir.
do whatever do what you do. Do your
Police
job.
officers
He
are
got a permit.
police officers are in your presence.
The First Amendment protects speech on private property, and the officer's threats infringed upon this right. Legal precedents underline the special protection for personal liberties within one's home. The officer's subsequent behavior with an unidentified woman, initially detained due to the reported theft, raises Fourth Amendment concerns. While reasonable suspicion justified her initial detention, the officers extended her handcuffed detention in a police cruiser even after she provided evidence that could have dispelled their suspicions. Courts have ruled that such extended detentions could transform investigative stops into arrest, violating the Fourth Amendment.
There it is.
That's not,
Okay.
that's not
You go to
how
law
law
school?
works.
You go
I did go to law school.
Okay, you passed the bar?
I did
So
pass
you're
the
a
bar.
lawyer?
I am a lawyer.
Okay.
I don't have to
Just
disarm
go in the
myself.
house.
That's not how the
Just
law
go in the
works.
house.
Come here.
I'm not going anywhere with you.
Come
Just go
I
in
have
the
not
house.
committed a crime. They know I haven't committed a crime.
Okay,
They know I have not
Everybody
committed a crime.
knows.
Amber, I want you to record them. I'm gonna make stars out of both of them.
ahead.
James and Zing. I'm gonna make big stars out of them. I love tyrants. I love tyrants like yourself.
Either you step inside or you go to
I'm
jail.
a private. I'm a law-abiding citizen.
5, 4,
I'm not your child.
Wait, hold on, wait.
Child.
Go.
I'm not your child.
No,
Bro, you're not scaring nobody with that fucking permit.
question or whatever.
You're not talking about.
Despite these issues, Mr. Branch managed to de-escalate the situation through assertive dialogue. He challenged the officers' actions while maintaining composure and asserting his rights. Eventually, the officers released the detained woman, but not without her being held for an excessive duration. Now, let's move on to the next investigation. In an incident that occurred on July 3, 2021, officers from the Elcart Police Department were called to respond to a disturbance at a hotel in Elcart, Indiana. The officers stopped 3 teenagers whom they believed to be responsible for the disturbance and demanded that they identify themselves. As tensions began to rise, one of the bystanders at the scene started recording the encounter.
It doesn't matter. Talking about us. It doesn't matter. It doesn't matter. He doesn't want you guys back here. And to verify that, I need your names so that if you do show up again, you can then go to jail. Okay? So what is your name? Before I put you all in handcuffs and take you all to jail. Okay. Then you're gonna. I ain't gonna lie. I ain't going to jail. Okay. What is your name?
Y'all ain't got no ride, man.
Yeah, we do. We ready.
Despite the potential escalation, the officers did not conduct a thorough investigation into the situation. According to best practices for police interactions, responding officers are expected to perform comprehensive preliminary investigations, including interviewing witnesses to accurately determine suspects. However, the officers in this case seemed uninterested in investigating further and instead continued to insist that the teenagers provide their identification.
Because we can't verify that you are the parent or guardian? We can't do that. So again, I'm going to ask again before you all go in. Does that make sense? What is your name? We can't just release
Well, hold on, let me talk to them. Alright, let's talk about it. But if they weren't part of the confusion, then I don't understand what's going on.
I told you multiple times.
The boys and bystanders maintained that they were not involved in the initial disturbance, but the officers did not seem willing to consider this possibility. The officers' conduct raised questions about their failure to follow proper investigation procedures, even though there is no legal obligation for police officers to conduct in-depth investigations.
You're not in trouble, man. But if you keep playing this game,
I want him to come out here before I say anything else.
They gone. They went out the back door.
Huh?
They went out the back door.
No, I'm talking about the manager that said that we was because he know it's not us.
No, it wasn't them.
Exactly. That's why I want him to come out here.
He doesn't want to come out here right now. Okay,
Man,
he has a job
alright,
to
we
do,
go
which
in
is
there.
inside. No, because he doesn't want you inside. He doesn't want you on the
He
property.
don't know it.
The bystander recording the incident questioned the officer's authority to detain the teenagers based on Indiana's trespassing laws. He argued that since the teenagers had not refused to leave the property when asked, they could not be considered trespassing. The officer countered by citing Indiana trespassing law, which allows charges to be brought against individuals who knowingly or intentionally refuse to leave private property after being asked to do so by the property owner or their agent. However, legal precedent indicated that a police officer who is neither the property owner nor an agent of the owner cannot create a trespass violation merely by asking someone to leave and then arresting them for noncompliance. In this instance, the officers were acting in their capacity as police officers and not as agents of the property owner, so their detention of the teenagers on suspicion of trespassing seemed unjustified.
These are not them. These are not them.
Would you like these gentlemen
Please
also
come out
trespass
here.
on the property? Or do
We didn't have nothing to do with that. Yes. No, they had nothing to do with it. All right, man, get my.
Stand up.
The other dude talking about the gun.
It was taller boys who are probably already all gone because they knew that you were coming. They don't want to.
That's what
Deal
I'm
with
saying.
police.
Until he come out here.
Fair enough, but when I walked in, he pointed to you gentlemen.
Man, that's all I wanted to come out. You got my name for nothing. You got my name for nothing.
You didn't want to come out.
It wasn't that hard for him to come out here and clear it up. He trying to put it in here to take him to
Sure,
jail.
because you're not cooperating.
You're not doing his
It's
job
easy
right.
for me to control the
Not doing his
situation.
job right.
I am doing my job right.
See, y'all don't know
What's your name, badge number?
They were talking about. They was in there talking about gunplay with this dude, man. That's
Sure,
what I said.
and
Y'all
when I
didn't
got
have
here,
nothing to do
and
with
listen,
it.
when I got here,
Yeah.
he pointed to these gentlemen.
We told you.
Okay,
The description that he gave.
I can't take your word for it when he pointed to you.
Furthermore, Indiana law does not have a stop and identify statute that mandates individuals to provide identification during criminal investigations. The statute requires individuals to provide identification to law enforcement officers, and that only applies when someone is stopped for an infraction or ordinance violation. This means that the officer's demand for identification lacked a legal basis.
He did. He pointed to you.
already in there,
He
bro.
pointed to you. Okay.
Name and badge number, please. Isn't Elcart policy for you to identify yourself to the public?
My guess is they probably already left.
Okay.
Because they all probably have their licenses.
That's fine.
And they drove off because they didn't want to deal with you guys.
The situation escalated further when one officer claimed that the hotel manager had misidentified the teenagers as the perpetrators of the disturbance. Despite the assertion from the bystanders that the detained teenagers were not involved, the officers seemed unwilling to reconsider their actions. The bystanders and teens remained composed, and with the intervention of the bystanders, the officers were eventually compelled to release the teenagers. Now let's take a look at another investigation. In a notable incident on June 12, 2020, a confrontation between an Amazon delivery driver named Deja Murphy and property owner Keith Miller in Lowell, Indiana, has brought to light the complexities of enforcing laws on private property. The incident, originally reported by the Times of Northwest Indiana and discussed on Lackluster's channel, involves issues related to traffic laws, private property rights, criminal confinement, and police authority. The situation unfolded when Miller, convinced that Murphy was speeding on his property, employed his truck to block her exit.
Good luck, buddy.
No. Bottom line is, I need your ID.
Sure.
You're going to pull your truck in your driveway.
Yep.
I'm going to get her information. I'm going to do a report, and we're going to go about our day.
I'm going to get my wallet from my office.
Huh?
No,
you're not. You're going to just give me your name and information.
Oh, sure.
I'm gonna,
You want me to write it down for you?
Yeah. I'm not spending all day with this. This is
I
ridiculous.
asked, and we have since put cameras up. I just said,
What's your last name?
Miller, M-I-L-L-E-R.
He proceeded to demand her identification, thereby initiating a tense standoff. Responding to Murphy's call, Officer John from the Lake County Sheriff's Department arrived at the scene. He clarified that he lacked jurisdiction to enforce speeding laws on private property, igniting a discourse on the distinction between public roads and private driveways. Indiana's legal framework underscores the limited jurisdiction of traffic laws on private property. State law specifies that highway regulations pertain to publicly maintained roads accessible for vehicular travel. In contrast, a private driveway, such as Miller's property, doesn't fall within this category. Therefore, Murphy's alleged speeding on the driveway couldn't be penalized as a traffic violation under Indiana law. However, exceptions do exist. In certain cases, police can enforce traffic rules on private property where the public's invited. This enforcement relies on local ordinances and agreements between property owners and law enforcement authorities. These provisions empower the police to regulate traffic and parking on private property under specific circumstances.
Thank you. Sorry. Pull forward. Okay, ma'am.
Okay.
I need your license.
Okay. And may I ask about these?
Because you called the police, he called the police,
Just making
and
sure. That's
I'm
all I want
called
to know.
here. That's why I need your information. That's all the information I need. And he's upset because you were speeding.
But
I
y'all
told him
wasn't.
he couldn't do what he's doing.
And
You're going to go on your way, and if you have any issues, you and your company can stop delivering here.
Okay.
How's that?
He came to my door. That's what bothered me. He came in my door, opened the door, told me to get the hell out my door.
While these local ordinances may not encompass the full scope of state traffic laws, they still grant authorities the capacity to uphold specific regulations. Miller's actions also raise questions about potential criminal charges. Officer Marshall suggested that his conduct might align with the crime of criminal confinement, defined as knowingly or intentionally restricting another person's liberty without consent.
That's harassment.
You know what? Let's stop.
Okay.
We're going to do a report. We're going to go about our day.
It's harassment, though.
Everything's everything. You know what?
That's harassment.
There'll be a report on file.
While Murphy's situation didn't precisely match this definition, it highlighted the broader issue of maintaining public safety and individual rights on private property.
To the prosecutor's office?
This is Lake County?
Yeah.
Yes. We'll give you a case number.
Yeah, I want the case number, too.
It'll be on the report, sir.
What's your name?
It'll be on the report. It's Marshall.
Marshall? Okay.
And tell your friend on the phone, I'm not upset with you.
That's my brother.
Oh, you know what?
You know, where everything's going on, that's the only reason why
Everyone's fine. We're here. I don't need your brother telling me my job and what we need to do. I think you need to get a hold of your supervisor and tell him.
Oh, no, we already talked.
Okay.
She was on the phone when all of this
Get a hold of your supervisor. What's the phone number you can reach that?
219-779.
The incident also touched on the concept of harassment. However, Indiana law defines harassment as involving communication with an intent to harass, annoy, or alarm another person without legitimate communication. Because this definition doesn't cover in-person interactions, Miller's actions toward Murphy, while unsettling, might not fall within the legal definition of harassment. Fundamentally, the incident underscores the scope of police authority concerning private property and the need to strike a balance between individual rights and public welfare. Indiana's police power enables the state to enact reasonable restrictions on private property to ensure community safety, health, and morality. While the jurisdiction of traffic laws on private driveways remains limited, criminal violations, regardless of the location, can still lead to police intervention.